I want to start off by acknowledging that we live in astonishing times. Generative AI models, trained essentially to predict the next word, can summarize, elaborate, extemporize. They can take a lesson plan you wrote for a fourth grader and convert it for an eighth grader. They can carry on a conversation. They can pass exams in law and medicine and accounting. They can create new visual art, new music, and new video. The products of generative AI can be indistinguishable from their human-authored counterparts, and yet they can be produced at a speed and a scale that transcends human ability. Generative AI models can take a paragraph of text, like my remarks thus far, and turn it into a pretty decent illustration using a few simple prompts in pretty much the same time it took to write those prompts. Generative AI is a global phenomenon. The majority of Fortune 500 companies around the world are integrating AI into their operations. Those who are not will probably not be Fortune 500 companies for very long. ChatGPT is, of course, available in 161 countries around the world, last time I checked, with almost 200 million users and 100 million weekly users. The governments of America, China, Britain, France, Germany, India, Saudi Arabia, the United Arab Emirates are all pouring in billions of dollars into AI research and the manufacture and development of advanced chips and foundation models. The rapid adoption of machine learning in general, and now generative AI in particular, has triggered fear as well as awe. Machine learning models are data dependent and typically inscrutable. That combination inevitably raises questions about privacy, validity, bias and representation, trustworthiness, and accountability. We're really only just beginning to grapple with questions such as, who is the author of an image created using Midjourney or DALL-E 3? Who is responsible for harmful medical advice or defamatory text produced by a chatbot? These questions inevitably lead to broader inquiries about the future of employment, education and invention, and even more fundamental questions about how we understand our place in the universe. Copyright is probably not the most important issue in relation to generative AI, but the copy-reliant nature of generative AI guarantees copyright a seat at the policy table. Today's large language models, which I'm just going to call LLMs from now on, and text-to-image models and text-to-video models, and all these whiz-bang things that you've been reading about for the past 18 months, they're all trained by exposure to vast amounts of material scraped from the open internet. Almost all of that material is subject to copyright. So what are the copyright implications of generative AI? Copyright was invented in England, in the Statute of Anne, in 1709, in response to the technology of the printing press. And although times have changed, the printing press remains our dominant metaphor for how copyright is supposed to work. Copyright, so the story goes, provides incentives for authors whose works would otherwise be freely copied upon first publication. And in this story, it's only natural to see the reproduction of a work as the locus of exchange between the reader and the author. But what if there is no reader? In the 1990s, for the first time, we began to see economically significant acts of copying that had nothing to do with the communication or transmission of the underlying expression. Those examples include reverse engineering object code in software, plagiarism detection systems, scraping HTML web pages to produce a search engine index, and conducting statistical analyses of entire libraries of books. I call these non-expressive uses because they're uses of copyrighted works for some reason other than enabling immediate or downstream enjoyment of the work's original expression. Non-expressive uses pose a real question for copyright law. On the one hand, the focal point of copyright law around the world is the right to reproduce works. On the other hand, the evident purpose underpinning that right is to allow the author to control the communication of her original expression to the public while still allowing facts, ideas, abstractions, artistic methods and techniques to be freely copied and shared. So the ultimate question, I think, in the context of generative AI is what is a fair balance between protecting the rights and interests and expectations of copyright owners and preserving the public's right to learn from and make free use of the uncopyrightable ideas, abstractions, and knowledge contained within those works. In answering that question, I would like to start with an observation about copyright law and then consider what that observation means for generative AI. My observation about copyright law, he says suspensefully, my observation about copyright law is simply that the idea-expression distinction, the distinction between protectable expression on the one hand and unprotectable facts, ideas, and abstractions on the other hand, that is actually universal. Copyright law around the world is harmonized to a significant extent through the TRIPS agreement under the World Trade Organization and the Berne Convention. Article 9.2 of the TRIPS agreement embodies a universal commitment to maintaining a distinction between copyrightable original expression and uncopyrightable ideas, procedures, methods of operation, or mathematical concepts as such. The idea-expression distinction is fundamental to modern copyright law. It explains why bad poetry, really bad poetry, is copyrightable, but good ideas, really good ideas, are uncopyrightable. Why facts are uncopyrightable, why discoveries are uncopyrightable, why artistic methods and abstractions are uncopyrightable and should be freely shared. The idea-expression distinction, I think, also tells us something interesting about what copyright is really for. It suggests to me that the purpose of copyright law is not to simply prohibit every technical act of reproduction for its own sake, regardless of purpose or effect. That it is to protect the author's rights vis-à-vis their original expression and the communication of that expression to the public. Allowing others to learn from existing expression, make observations about it, even to convert it into useful metadata, is just as important to the overall scheme of copyright as giving authors the right to object to expressive substitution. With that observation, with that understanding of the essential nature of copyright at hand, I think we can now take a closer look at generative AI and how it relates to copyright. There are lots of different forms of generative AI, but mostly I'm going to talk about LLMs, large language models, and text-to-image models like Stable Diffusion, DALL-E 3, and Midjourney, because I think they're easiest to illustrate. To understand the implications of copyright for generative AI, I think we need to appreciate three fundamental things. The first is that the gathering and pre-processing of training data for something like a large language model inevitably involves copying. And when I say copying, I mean a lot of copying. I mean copying not just in the hundreds, not just in the thousands, but almost inevitably in the hundreds of millions and the billions. The first stage in developing a machine learning model, once you know what you want the model to do and how you want it to do it, is to identify and obtain access to the relevant training data. The more data, the better, because these models are trained, the more data, the better, because models trained on more data are more generalizable and better at dealing with less common inputs. GPT-4, for example, which I'm going to assume everyone is at least somewhat familiar with, was trained on at least hundreds of millions of digital artifacts scraped from the open internet. Almost invariably, this data is copyrighted. Almost invariably, this data is stored locally. It's stored on a server, probably somewhere in Mountain View, California, where it can be analyzed, filtered, and deduplicated before training begins. So if you look at my slide here, these orange components, this is copying. This is something that is prima facie unlawful without the consent of the copyright owner in every jurisdiction. These are real copies, but in some ways they're strange copies. They meet the statutory definition of reproduction. They are in a medium that is stable from which they can be perceived and communicated. But they are also hidden copies, invisible copies that are only ever read by machines. The next fundamental point about generative AI models is that the model itself is something quite different to the training data. And if everything goes well, the model is not a copy of the training data. Large language models, for example, are trained to predict the next token in a sequence of tokens. Each token is a word or a part of a word or a punctuation mark. For ease of exposition, I'm going to talk about in terms of words rather than tokens. A model like GPT-4 consists of billions, possibly a trillion, parameters arranged in layers to handle different types of transformations with different levels of abstraction. It is essentially an absurdly large statistical model that attempts to predict the next word. At the beginning of training, that absurdly large model is gibberish. It is a set of weights that are assigned effectively at random. As the model is trained, those weights on the parameters are updated in a way that reflects the model getting better at guessing the next word. So if you start with a sentence like, the girl with the dark, and I'm going to say, Derek, can you tell me the next word? Hair. This almost never fails to work. Everyone guesses hair. I should now ask Derek why he guessed hair. Which book did he plagiarize it from? Right? That is obviously an absurd question. Right? Derek guessed hair because he's learned a lot about the English language, a lot about grammar and syntax, and also has imbibed subconsciously a great deal about Western society and literary culture, such that he knows the kind of observations we make in writing about girls are almost definitely going to be about their physical appearance, and then hair becomes a pretty good guess, right? This sentence appears in many books. Right? I found at least 15 looking on Google Books. It appears in many other contexts. Derek might have read it one day on the side of a bus, but he doesn't need to have ever read it to know that it's a good guess, because somewhere in his mind, he has learned much more abstract things about language and the world that tells him that hair was a pretty good guess, and light and galaxy and telephone and semicolon and harmonica were pretty terrible guesses. So the first time a model like GPT encounters a phrase like the girl with the dark and then is asked to guess the next token, it's actually just as likely to fill in that blank with watermelon or galaxy or propeller or semicolon. However, over the course of training, the system effectively updates the weights in the model, reinforcing the weights that led it to make better guesses and downvoting the weights that led it to make inferior guesses. And so those weights don't reflect any single text. They don't reflect any single round of training. They are the sort of the accumulation of multiple rounds of training. And when I say multiple rounds of training, I really mean an unfathomably large number of operations. When a language model learns to associate a higher probability with hair and a lower probability with propeller or harmonica in this context, it's not copying the text. It is, in a very real sense, learning from the text. And I know, and I'll be one of the first people to tell you, analogies to human cognition and the way machine learning models work can be and are often overstated. But if we have to choose between describing these systems as copying like a scribe in a monastery or learning like a student, it's definitely closer to the second one. If these models are set up correctly, they are forced to learn at a somewhat abstract and uncopyrightable level, rather than simply memorizing the training data. To see this process of abstraction in action, I'd like you to consider what happens to the hundreds of images labeled coffee cup in the Leon 5B dataset that was used to train text-to-image models like Stable Diffusion and Midjourney. So what you can see here is a random set of coffee cup images from the Stable Diffusion training data on the left, and a newly rendered coffee cup that is also a portal to another dimension on the right. The coffee cup depicted on the right shares a lot of features in common with some of the coffee cups on the left, right? It's round, it's wide, it's ceramic, it has one small handle. It has a liquid in that kind of looks like coffee in the sense that it's sort of brownish, blackish. However, you will see all the material that's been abstracted away, right? Gone are the sunsets, sunrises, women with smooth skin, men with facial hair, Pikachu, coffee beans, attractive little cakes, green fields, ocean vistas, etc. Right? As the model learns a sort of latent representation of a coffee cup, it is, in this case, genuinely abstracting from the input images to something that is a little more refined and fundamental. This leads me to my next point. The digital artifacts that are produced by generative AI models are not copies of the training data either, by which I mean that if you had created them through any other kind of process, no one would think that you met copyright's criteria of substantial similarity. Partly, this is because the models, if they're set up correctly, only learn abstract and uncopyrightable associations from the training data. If that's right, then at the point of inference, which you can think of as entering a prompt into Midjourney, asking it to do something, that information, if it hasn't been stored, it can't be retrieved. But it's also important to understand that at the point of inference, the outputs of generative AI typically combine multiple uncopyrightable latent features, further attenuating or breaking the chain between the training data and the model output. And so I would ask you to consider, for example, the image that Midjourney produced for me in response to my prompt calling for a teddy bear in rich, opulent clothing with ultra-realistic textures and a hypnotic stare reading a newspaper. No doubt, the picture is influenced by thousands of images paired with each of the relevant keywords. All of the images of teddy bears in the training data inform some kind of latent construct of a teddy bear. Words that I never really thought I would get to utter. The latent the latent construct of a teddy bear nested within the model's latent space. Likewise, all of the images of hypnotic stares and reading newspapers, etc. But when it comes together, the product of this prompt is something entirely new. Like, this image does not exist in the training data. This is not a version of something in the training data. This is something absolutely, genuinely new. Models like Midjourney don't just combine and unpack learned latent features. They generate novel instances. And that's a really important thing to understand because, again, it separates the outputs of these models from the inputs. This picture is not just new, it's actually surprising. Right? The fun thing here is we asked for a hypnotic stare and the bear is wearing sunglasses. So we don't actually know whether the bear is staring or asleep. We just know that this bear has a lot of attitude. So let me recap on these points. Right. Point number one, to build a generative AI model inevitably requires a massive amount of copying. That copying actually occurs prior to training. It's in the assemblage of all of the data for training. The second point, point number B, is that the model that results from training is separate from the training data. It's not a copy of the training data. Point number C is that the digital artifacts produced by generative AI models are also not copies of the training data. The combination of B and C has some really important implications. The first implication is that it makes the fair use argument stronger. The fact that the model is only learning uncopyrightable features and thus poses no threat of direct expressive substitution, that really is the crux of the fair use argument under United States copyright law. This is the feature of generative AI that makes it consistent with prior cases on reverse engineering, plagiarism detection, book search, and literary analysis. The second implication, and this is a really important implication for countries like Australia that don't have a fair use doctrine or anything equivalent, is that once you train the model lawfully in one jurisdiction, you're free to export that model to other jurisdictions. You don't even need to export the model to other jurisdictions. You can just set up a pipeline to where the model is hosted, but you can also take the model and you can bring it to Sydney. You can put it on an edge device because the model is not a copy of the training data, so there's no reason under copyright law to object to that model coming into the country and being used here. Concretely, what this means is that if your model was trained in Japan or Israel or the United States, and it's not itself a copy of the training data, then there's nothing that a copyright owner whose works were used in the training data could do to object to the use or indeed reproduction of that model. And this obviously suggests a kind of copyright regulatory arbitrage. Companies obviously can and will train their models in jurisdictions that are more flexible and then use those models worldwide. It also suggests that for countries like Australia with highly restrictive copyright laws, these laws will only impede their domestic academic institutions who don't have this kind of mobility and perhaps drive some commercial development offshore. But it certainly won't impede the broader global development of generative AI. I don't want to suggest that all of this is or should be plain sailing for the likes of Google and OpenAI. To see why, we need to account for 4 complications to the admittedly simplified story that I've been telling so far. The first complication, and this is a big one, when I told you that generative AI models don't memorize the training data and don't produce copies of the training data, that's just not always true. Right? Sometimes generative AI models will overfit to the training data and memorize specific details rather than learning more abstractly. The computer science literature suggests that memorization is very much an edge case, but is more likely when models are trained on many duplicates of the same work, which is why it's so easy to get GPT to reproduce Harry Potter before they put filters on. It's also more likely in image models when the images are actually attached to highly unique textual descriptions. And it also seems to be more common when the ratio of the model size to the training data is relatively large, right? And this makes sense. If the training data is this big and the model is this big, the model is forced to abstract the training data at a certain point. But as the models become larger and larger and larger, their ability to memorize rather than abstracting seems to increase. I believe that this kind of memorization is still very much an edge case, but it is interesting to think about whether it will become more problematic as we go from GPT-4 to GPT-5, which is reported to be, another 10x in model size. The second complication is the Snoopy problem. My research indicates, and when I say research, I literally mean hours and hours playing around with Midjourney and DALL-E 2, but it's good to call it research. My research indicates that text-to-image models are prone to produce potentially infringing images when text descriptions are paired with relatively simple reoccurring images with minor differences. So this makes Stable Diffusion especially likely to generate images that would infringe on a copyrightable character such as Snoopy and Baby Yoda, because these characters appear often enough in the training data that the model learns their consistent traits and attributes. I refer to this as the Snoopy problem. You all know what Snoopy looks like, and from the images that I produced here with Midjourney and Stable Diffusion, it's clear that these models do too. Because the character of Snoopy is protected so broadly, you can infringe the copyright in Snoopy with images that are not actually substantially similar to any particular pre-existing Snoopy image, right? It is enough that the image is recognizably the world's most famous beagle. So this is a problem for generative AI, because even if you have a system that is set up not to reproduce specific pieces of the training data, it's just a much harder challenge to get it not to reproduce things that are protected more abstractly. The third problem is that sometimes the model is an agent. We have models that don't just predict the next word anymore. We have models that are now capable of actually performing actions. So in a court filing late last year, in their lawsuit against OpenAI, the New York Times provided 100 examples of significant, and I would say, quite frankly, astonishing memorization. But a more careful look at the New York Times complaint hints that some of their examples are not actually about memorization, they're about something else. When you query ChatGPT without access to the internet, all you are getting is a prediction of the next word and the next word after that, and so on. But slides are out of order. But for quite a while now, ChatGPT, if you set it to GPT-4, has had the ability to treat your prompt as an instruction to look things up on the internet. Thus, GPT-4 knows that Scott Morrison is not the Prime Minister of Australia and that Anthony Albanese is. GPT 3.5, that has no access to the internet, the best guess it can do is to say, well, I think it's Scott Morrison, but my training data is not very up to date. The exhibits in the New York Times complaint against OpenAI look like they're the result of the model interpreting prompts as instructions to retrieve the text from the internet. This process of synthetic search usually involves distilling and integrating a few different sources, but with the right prompting, and the New York Times doesn't disclose its full prompting strategy, it can end up functioning as direct text retrieval. This is still potentially a copyright problem for OpenAI, but it's a much, much smaller copyright problem than if the model itself was actually memorizing vast swathes of the training data. The fourth complication is that generative AI can become a tool of infringement in the hands of a determined user. A user with detailed knowledge of a copyrighted work might be able to remake it, at least to a vague level of similarity. Of course, this is easier if works are protected at a more abstract level, like copyrightable characters, or works that customarily entail very broad derivative rights, like a novel. So for example, I asked ChatGPT to summarize Saturday by Ian McEwan, and then to imagine a sequel to this book called Sunday, where Perone and Baxter meet again. It outlined a simple plot, continuing the story, that could easily be fleshed out into what ChatGPT itself described as a meditative exploration of the aftermath of trauma and the possibilities of redemption and the enduring nature of human connection in the contemplative style of Ian McEwan. If I asked ChatGPT to expand on each one of the chapter descriptions, I could generate my very own Ian McEwan novel. So in the right hands, I should say it's not going to be very good. But the first paragraph here is not bad either. In the right hands, a model like ChatGPT can be a tool of copyright infringement, but the same is also true of typewriter. Right? It seems clear that not every act of infringement committed using generative AI should fairly be attributed to the entities that host or develop these models, but that on the other hand, some probably should. So with those observations and complications in mind, let's examine how countries around the world, other than Australia so far, are addressing the intersection of copyright and generative AI. In the United States, non-expressive uses have been recognized as highly transformative and quintessentially transformative, and thus are very likely to be recognized as fair use, all else being equal. I first made this argument in a 2009 Law Review article, largely derived from copyright law theory and first principles, but it's since been supported by case law, including the very important 2013 Hathitrust case and the 2015 case of Google Books. It's worth noting that because the US, It's worth noting that because the US position on AI training is a product of case law, there is some uncertainty as to its application in individual cases. And I'm more than happy to talk about the current crop of lawsuits in question and answer. But nonetheless, I think it's fairly clear that at least some AI training is protected by fair use, and probably quite a lot. Other jurisdictions began addressing the copyright implications of non-expressive use in relation to text data mining at a time when the logic of seeing non-expressive use as fair use was apparent in the United States, but the case law was actually quite scarce. Japan was the first mover here, followed shortly by the UK, and then eventually by Switzerland, the European Union, and Singapore. In a parallel development, a number of jurisdictions began adopting a version of the American fair use doctrine into their copyright law, motivated by the technological advantage that fair use appeared to have given the the United States. And I think Israel, South Korea, and Singapore are particularly important examples here. Putting this all together, there is a significant scope for training AI models on copyrighted works in Japan, the United Kingdom, Switzerland, the European Union, Singapore, the United States, and Israel. And in most of these jurisdictions, this extends to commercial as well as non-commercial applications. In terms of global population, these countries and jurisdictions account for about 12%. But in terms of global GDP, this is almost exactly half. Right? And I will note, I haven't included China here because a co-author and I are doing some research on China, and specific categorization was a little bit premature. Drilling down, we can see that the jurisdictions that have enacted specific text data mining exemptions have made different choices about implementation. For example, they've made different choices on how broadly the exemption should apply, whether it should be subject to a lawful access requirement, how to address contractual and technological overrides imposed by rights holders. Furthermore, in jurisdictions where the legality of text data mining and AI training depends on the application of the fair use standard, there is still some uncertainty as to how courts will ultimately rule on these same points of detail. Nonetheless, I think we see a broad agreement on at least the following three principles. First, learning abstract and uncopyrightable information from copyrighted works is socially valuable and does not inherently prejudice the rights and interests that copyright is designed to protect. Second, the copying inherent in building AI models and other forms of text data mining research should be allowed without the express consent of copyright owners, at least in some circumstances. Third, the right to engage in AI training and other forms of text data mining should not be a blank check. The right to engage in TDM is either limited by definition to non-expressive uses, which is the case in Japan, or it's subject to various considerations that are meant to address prejudice to the copyright owner. So where does this leave countries like Australia? Under current Australian law, as I understand it, the only way to train an AI model that is not strictly for research purposes would be to obtain the express permission of each and every rights holder, or to confine the training to works in the public domain, which, and the Australians will help me out here, it's like 1950 and before, more or less. When we're dealing with data sets in the hundreds of millions or the billions, the impracticability of this kind of work-by-work consent approach becomes, I think, fairly obvious. Australian companies can, of course, still use base models trained overseas and fine-tune those models on licensed content. But there could never be an OpenAI or an Anthropic in Australia under current Australian law. So, what should Australia do? What are the options that are open? Fairly simply, Australia could just adopt a US-style open-ended fair use provision into its copyright law. As we've already heard in the introduction, there was a Law Reform Commission that proposed that in 2013. The Productivity Commission proposed that in 2017. And it looks like this will never happen. Another thing that Australia could do is they could just add to the fair dealing provisions. They could create an express fair dealing provision for text data mining, or a fair dealing for AI training or machine learning training. This would be an elegant solution. It would bring Australia into line with its overseas competitors without a wholesale adoption of the US fair use doctrine that seems so politically impossible here in the current moment. Alternatively, Australia could adopt an express text data mining exemption modelled on the Japanese provision, or more conservatively, modelled on the European Union Digital Single Market Directives 3 and 4. There has been a lot of discussion in the US and in Europe, and I believe here to some extent, on collective licensing, by which I mean some kind of compulsory license to facilitate AI training. I fundamentally don't understand how this could ever work. Right? Performing rights organizations are efficient at distributing royalties because they only send money when an artist's work is actually used. In many countries, they only send money when an artist hits a certain dollar threshold, and that's the thing that really makes efficient distribution possible. But with generative AI, there are no Taylor Swifts, right? There's no way of knowing how much of a contribution each work makes to the training data, so the royalties would have to be divided equally. And even if we imagined a $1 billion royalty fund, the transactions of dividing that pie into 1 billion equal pieces and mailing out a check to each rights holder clearly would exceed the revenue of that fund, right? I think that most people advocating for compulsory licenses in the US secretly understand this, and what they're really envisaging is an AI training tax that would go to fund worthy causes. Right? This might be good social policy, but it's not going to be the same as ASCAP or performing rights organizations. What else could Australia do? Australia could adopt some kind of safe harbor for AI training that was conditional on submitting and having approved a satisfactory AI safety proposal. The advantage here would be that you could integrate an assessment of different kinds of risks posed by generative AI. Many of the copyright, trademark, privacy, indigenous sensitivity, and right of publicity issues that can arise with generative AI are much better addressed before training begins than being patched afterwards. Under this safe harbor, researchers and companies would get an exemption from copyright liability for the copying inherent in training if their proposal was approved and they stuck to the parameters of their proposal. But they would still not get any immunity from copyright liability for artifacts that the model produced, because we already have standard tools of copyright law to address that. The final solution would be for Australia to simply do nothing and cede the field to countries like Israel, Japan, Singapore, South Korea, and of course the EU and the United States. I'm not sure that that's a great option for the clever country. And with that, I welcome your questions.